Good afternoon and welcome to our webinar. I'm Diana Maier and I have Beth Arnese with me. And I'll introduce us in a second, but first I wanted to introduce our webinar and go over some housekeeping items. This is Terminating Employees in California, and there is CLE credit for this webinar. You can email Lauren at dianamairlaw.com and give her your CLE number, and she will send you a certificate of attendance once we get the approval from the Bar Association, which should be happening in a week or so. The PowerPoint for this presentation is also going to be up on the website, and if you register for this webinar, it should have been sent to you by Lauren as well. There's a link to it in your email. If you would like the PowerPoint and you'd like to have it not in SlideShare as it will be displayed on the website, you can again email Lauren at Diana Maier Law, who is our paralegal, and she'll send it on to you. As questions come up, just feel free to fill out the chat bar and send it on through, and we will answer those as they come up and take some more questions at the end as well. So here we go. So again, I'm Diana Maier, and I graduated from law school at Stanford in 1998, so it's actually been more than 18 years that I've been practicing law. I was a public defender originally, and then I got into employment law, plaintiff side employment law right out of criminal defense work, and I did that for a few years and then decided that I really wanted to do preventative employment law, and I got into more defense side work, and I've been doing that ever since. I also have an expertise in privacy law, and I'm certified by the International Association of Privacy Professionals in both U.S. privacy law and European Union privacy law. And finally, I do quite a bit of investigations in both Spanish and English because I'm bilingual. And the lovely Beth Arnese received her JD from UCLA Law School in 2005. So she's been practicing for over 10 years. And she worked primarily at a large firm for many years and then joined the public sector and recently came to me in January of 2016. She specializes in litigation, and she also has expertise in employment and privacy law. Beth also conducts workplace investigations. So how much notice is required before termination? Well, most of you know that California is an at-will state, meaning that the employer or the employee can terminate the employment relationship at any time with or without cause. So sometimes it's said that employers can terminate for any reason or no reason, just not an illegal reason. Of course, employers always do have a reason for terminating, but we'll get into that later on. So the thing that you want to think about in terms of notice in an at-will state is just, have you elected to give notice even so? So your employment contract or your offer letter, which essentially is like an employment contract, might specify an amount of notice that will be provided to the employee. And then in that case, you formed a contractual obligation to give a certain amount of notice. So it is a good idea to do a few things before you terminate, such as reviewing the original offer letter and seeing, besides notice, are there other promises that you've made? And to make sure that you follow those promises. And finally, to think about, does your company have a policy of progressive discipline, and was it followed in this case? Now, a lot of times I get questions about that because we are an at-will state, and as was said before, you don't need a reason to terminate. But of course, employers always do have a reason to terminate. They don't just terminate for no reason at all. It wouldn't make any sense. So employees will often assume a reason, and by laying out the performance concerns early and often, you do prevent employees from making their own minds up about what is going on and filling in a negative or illegal reason. It also allows, when you do a graduated performance plan, it allows for employee buy-in. Of course, some of your employees are never going to buy in. They're never going to think that there is a meritorious motive. But some employees will, and they'll be interested in changing. And those are the employees that you want to really, think about when you are thinking about what your practices are going to be. Also, when you face a lawsuit, a lot of times there is a reason given by the employer, but the employee believes a different reason is really the problem or the issue. And so when you have a history of performance improvement counseling, it does lend itself to showing that the employer really did try and that the employee really just couldn't cut it, or the employee was intractable and wasn't willing to improve. But it can generate some compassion, some sympathy for the defendant in the case, which is often that sympathy and compassion goes to the employee, not the employer. So it is a way to level the playing field in cases of lawsuit. And again, it will show that rather than a pretext, there really were real performance issues that went on that just couldn't be solved. The best strategy is to document performance issues from the moment they occur and show the employee your documentation, have them sign off on it. And, it's fine if they don't write that, I agree with everything in this performance improvement plan or this probationary document or whatever it is that you're giving them. But it is good for them just to sign to say they saw it, so they can't later claim that they never saw it or it was never given to them. Also, I think a key thing in having a successful progressive discipline program is to praise the positives. If you're only ever handing out negative feedback, then an employee stops taking it seriously. But if you're also giving positive feedback, when you start giving that negative feedback, of course, it really lands. So that's another thing to think about. Finally, employees can and do change. And I've seen a couple of situations, not that many, but I certainly have seen a few where a termination really didn't end up being necessary. Maybe the PIP was implemented, in fact, just to prepare for termination, but the employer went into it with a good faith attempt to make things better, and the employee really worked hard and got themselves back on track. So that could obviously alleviate the need to ever terminate, and that's always something that you want to try and do whenever possible. I have a question here about, is this information different for public employees with civil service protections? And yes, it definitely is different. Of course, it's going to depend and vary greatly depending on what that situation is. But if you have some kind of a civil service protection, obviously you're going to have to go through a whole additional process to terminate, and you're going to have to go through a different process. And I think that is maybe a topic for another day, but suffice it to say that, yes, it's a good point that even though we're an at-will state, when we are dealing with civil service protections, there is a higher standard required, and generally you're going to need to show cause when you terminate someone. Finally, some additional things to think about are making sure that you apply your procedures and policies consistently. Again, this is not legally required. For example, just like progressive discipline isn't legally required, but doing the same thing for all your employees is going to make you subject to a lot less allegations of discrimination. I do think it's important to keep the termination confidential and telling those only who need to know. Of course, it's fine to decide with the employee what you're going to tell the company about why they left, but in terms of the real reasons that you terminated someone, if they're not flattering to the employee, I think it's important to only let the employee know, and the one or two people that really need to know that. And the reason for that is because there's been a huge uptick in defamation lawsuits in California. And while the truth is a defense to defamation, so I'm not saying these suits would be, successful, it's just a pain. It's so much time and money and energy to have to defend a lawsuit. And sometimes if somebody gets the advice that they're not entitled to any employment law reparations, they may go after the defamation part of it. So just keeping that termination, the real reasons for it, under wraps. And that, I think, too, is also a way to respect the privacy of the person being terminated. Again, agreeing with them on what you're going to say so you have a united front, and being really careful what you say to the more general public about it is really important. And now Beth is going to talk about the required forms and notices when you terminate someone.
Great. So I'm sure most of you realize that there are several required forms and notices that you need to provide to an employee upon termination. And today I'm going to kind of break them down into two categories. The first I'll talk about are forms that are required under federal law. And under federal law, you do need to provide a COBRA continuation coverage election notice. This is filled out by the plan administrator. It comes from the healthcare plan. They are required to provide it within 14 days of notice of the termination, and they send that to each qualified beneficiary. So the bottom line here for employers is that they must notify the plan right away so that those forms can go out in a timely manner. So also another federal requirement that most likely will not come into play for smaller companies is a notice under the WARN Act. Under the WARN Act, you have to notify employees 60 days prior to termination, but this has very specific requirements. So you can either have a plant closing, which is defined under the Act as an employment site with 50 or more employees who are being laid off within 30 days, or a mass layoff. And that's defined either as 500 or more employees being laid off within 30 days, or you could have 50 to 499 employees if they constitute more than 1/3 of your workforce. And again, we're talking about a 30-day period here. So these are very specific requirements that you should be aware of. And if you are doing a kind of larger layoff, you should at least consider this and maybe refresh your memory about the actual requirements. Note that this can also apply to the sale of a business or part of a business if it would cause a plant closing or a mass layoff. And also the buyer can be responsible if closings would happen after the purchase. So this is just kind of all things to keep in mind, to consider. The WARN Act requirements, as I mentioned, are very specific and probably could be provide enough information for a whole webinar, but we're not going to get into the details of that today, just so you know about it. And now under California, we have a requirement to provide a HIP notice and an EDD pamphlet called For Your Benefit. These are two documents that are available online. I should say they're easily available online. So on the day of termination, this should just be part of the set of documents and information that you're giving to the employee.
And there's, incidentally, there is a link to all these notices on my latest blog post on employee terminations.
Great, yeah. So that's also, we'll talk about that a little bit at the end, but we do have a lot of material on our website about employee termination, including links to all of these forms and just sort of the kind of background basic legal issues that come up over and over. So a question that we often hear when we're consulting with companies is a termination letter required in California? And you do have to provide something called a notice to employee as to change in relationship form. It has very basic information that you're providing to the employee. And it sets forth really the minimum amount of information that you're required to provide. You, as the employer, are always able to provide more information if you choose to do that. And this notice to employee as to change in relationship is also under the California Unemployment Insurance Code, Section 1089, if you need to find that. And then finally, under California law, CalCOBRA may apply if you're a small company. It applies to companies that have between 2 and 19 employees, and also it applies when employees have exhausted COBRA, their federal COBRA benefits. So CalCOBRA allows people to continue group health coverage for up to 36 months. This would come into play in an example where you would have someone on COBRA for 18 months and then CalCOBRA for an additional 18 months. So we have a question about, I believe it's about the last slide, the notice to employee as to change in relationship and whether that's required for businesses less than 50 employees. And Diana and I are pretty confident that that does apply to businesses with less than 50 employees.
But you know what, I'll look it up right now so we're sure. I'm just looking at the, there's another question regarding the notice to employees as to change in relationship. Is that normally given, does that have to be given to an employee in disciplinary suspensions as well? I actually don't know the answer to that, but if you look at the form, the EDD's form, it does say you will be out on a leave of absence starting on blank date. So I'm going to assume you do. And again, I can look this up while we're giving the webinar, and hopefully I'll find an answer and I can circle back with you all. But I think just generally any kind of significant change in your employment status, you need to give a notice.
Yeah,
is that your understanding, Beth?
I'd agree with that, absolutely. Okay, now we'll just return to, okay, so CalCobra. One final note on this slide on CalCobra is just that carriers handle CalCobra differently. So if you're terminating an employee, you should just determine what your requirements are vis-a-vis your carrier. You may have to notify them by mail or fax, or they may have some specific timing or whatnot, and just make sure that you're complying with all that. Okay, final wages. This is a really important part about termination, and the reason it's important is because there are fairly significant penalties if you fail to properly pay final wages on time when you're required to under California law. And basically the law is that employers have to have the entire paycheck ready to go at the moment of termination, which includes unused vacation, as that is considered a wage in California. If the employee quits and you're not dealing with the termination, then you have 72 hours to provide a final paycheck. And even if they storm out, you still have to send it to them within 72 hours. And as I mentioned, failure to pay the final paycheck at the time of termination will result in hefty fines, many times the amount owed. So when you're terminating someone and when you're trying to kind of calculate their final wages so you can have that final paycheck prepared, there are some things to consider. If you have someone who could earn commissions, you have to pay commissions on the date of discharge for all commissions that have been earned. And this can be somewhat complicated depending on how your company defines when a commission is earned. So, for example, your company may have a policy that when a payment is received, it is earned. And you would basically have to figure out if the payment had been received, if the commission had been earned, and then if it had, you need to make sure that you're including that payment in the final paycheck. So on the other hand, if the commission has not yet been earned, you have to pay that immediately upon satisfaction of the condition precedent. So that's a very kind of fancy way of saying, using our example, once the customer does make the payment, then at that point the commission would be earned and the employer has the obligation to pay that immediately. One other item that needs to be included in your final wages is non-discretionary bonuses or profit sharing agreements. And again, obviously this is not going to apply to every employee who's being terminated, but it's just something that you need to be aware of so that you can determine whether there are any non-discretionary bonuses or profit sharing agreements that would apply in your case. Finally, just in terms of the logistics of paying the final wages, can you do that by direct deposit? And under California law, direct deposits are allowed with written authorization, but at the time of termination, that authorization immediately terminates. At the time of termination or when someone quits. So you could either get their agreement again for a direct deposit, it would have to be a new agreement, or you could just pay them with a physical hard copy check. But the same rules about timing apply. So we talked about this briefly, but I think this is just good background that everybody should be aware of, which is how long medical coverage continues. And this is a little bit interesting to see what will happen with, Covered California, I think is probably changing this quite a bit. But you should be aware that under COBRA, group coverage can continue for 18 months. And then if you have a second qualifying event, it might extend up to 36 months. Either you may have something like a divorce or a death of an employee, which would extend the coverage, or CalCOBRA might come into play, extending it up to 36 months. Unemployment insurance. Another big issue in terminations that everybody should know something about. So if you have a former employee who files for unemployment insurance, then the next step is that you will receive from EDD a form called Notice of Unemployment Claim Filed. And as the employer, you have 10 days to contest that in writing. If you do contest, the response should contain all relevant facts showing that the employee is not eligible. And I think most people have an understanding that the employer's rates go up if the former employee does end up taking unemployment insurance. However, there are certain circumstances under which a former employee is not eligible for unemployment insurance. And one of the big ones is termination for misconduct. This is a pretty high standard, and it has a very specific legal definition. So you have to have an employee who owed a material duty to an employer. There was a substantial breach of that duty. The breach showed a wanton or willful disregard of the employer, and the breach tended to harm the employer's business interests. So examples of someone being terminated for misconduct include someone who's terminated for violation of a reasonable employer rule, someone with deliberate and continued insubordination, or repeated tardiness or work absences. Things that would not be considered misconduct are poor job performance or personality issues. And then also just note that if you have an employee who's voluntarily quitting without good cause, that person will be ineligible for unemployment. And now I'm going to turn it back to Diana to talk about severance pay.
Great. By the way, I looked up this question about whether you are required to give a notice as to change in relationship for disciplinary suspensions. There's really no clear answer to me. I mean, the EDD is really its own universe, and so it's really, I think the only way to know for sure, I mean, I did some perusing, but I think the only way to know for sure is to ask them. But I'm going to say, given what the form says, that it's not a bad idea. I mean, there's no harm in doing it. And for that matter, I mean, none of these things, I've never, for example, had a client, I know a lot of my clients don't give a notice as to change in relationship, and I've never seen them actually be assessed, monetary penalties, but they certainly could be. And so, this is just really an abundance of caution, knowing what California law requires. But I would say it'd be a good idea, but technically everything I saw online said you give it when someone is laid off or terminated. But I just don't see what the harm would be, so I think it's a good idea to give it. So getting into severance pay here, California does not require severance pay, but I think that there are a lot of good reasons for giving severance pay. And of course, good minds differ on this. One of the places where I work, I'm essentially their outsourced in-house counsel for employment law, is the head of HR there feels really strongly that we do not have a policy of giving severance and getting a release from employees, because the employer is a very good employer, and she feels like it gives ideas to people about, there's language in there about consulting with an attorney, and, that people then go to an attorney, and, just that it creates an incentive essentially for an employee to start down this road of really analyzing their termination. And I think that's a completely valid perspective. I don't think, in my opinion, California employees are quite savvy. And if anything, I think they have an overstated sense of what's against the law. And so my feeling is people know to go talk to attorneys anyway. And because it's such a inexpensive way of buying yourself a little peace of mind, and it's also a nice thing to do for the employee. I am a fan of giving severance in exchange for getting a release of claims. So the nice thing about offering severance is that you can avoid any potential disputes, and even meritless claims, of course, can be quite expensive for the employer. And obviously it can make a layoff or a termination more bearable. In exchange, again, I really advocate that you not give a severance payment without asking for a release in exchange. So, of course, it means you'll have to pay out some additional monies, but most employers tend to do that anyway. So a lot of times it's just changing the practice so that instead of just giving 2 weeks, you give 2 weeks and you ask for a release. Or maybe you give one a slightly, an additional week or a little bit more time and you ask for the release. So this is going to get into a little bit of the finer points of drafting severance agreements. So those of you who haven't done them, this may not make a lot of sense to you, but I thought we would just briefly touch on this. If you have an employee who's over 40, the most important thing to know is that there's special requirements for a severance agreement. So you probably want to think about having an attorney look at it, or looking this up and just making sure you got it right. There is the Age Discrimination in Employment Act, and that applies to all employees federally, nationwide, who are over 40. So believe it or not, that is the age of, I guess after 40, you're just old. That is when there are age protections. And the language in the agreement has to specifically say that the employee has 21 days to consider the agreement before signing. So that period of time can be waived. The employee can look at it and decide that they don't care, they want to sign it on the spot, they don't think anything wrong happened, and they want to sign then and there. That's fine. There is another 7 days, though, that cannot be waived. That is a revocation period. So even after the employee signs it, they then have 7 days to inform you that they completely reverse what they signed and they're not interested. So you got to wait until that period of time passes before you pay out the severance as well, or you're looking at basically paying out severance and not getting anything in exchange. The other thing that your agreement should say is it should recommend that they consult with an attorney prior to executing the agreement. And I think it's actually a really good idea to have in your agreements generally, because then you're not risking somebody coming back later and saying, well, I really didn't understand this, and I signed it, at the time of termination when I was really a wreck, and so on and so forth. So I don't think it's a bad thing to put in there. And I do think it actually, in some ways, can be a comfort to the employee. They can figure that if you're advising them to go to an attorney, there's probably not anything in there that is really that worrisome to them. So I think it's a good idea on a lot of levels. So if you have a group layoff with employees over 40, so say you've got a program set up where employees there's a program in place where they get a certain amount of severance in exchange for them signing a release, and you have a group of employees who are laid off, then they have 45 days. So that 21-day period basically doubles, and they've got 45 days to consider the waiver, consider the agreement before they sign it.
but, consider their waiver of rights or the release to claims. There's also a lot of additional rules about information the employer has to give out. So they've got to essentially tell the employee, who else is being terminated and who's staying. And essentially, they've got to allow the employee to take a look at the numbers and see if there's anything fishy going on. If everybody else who's being terminated, say, is over 40 and everyone who's staying on is younger than 40, that might be a concern. And that person might decide that they don't want to sign the release. And that's exactly what the ADA is, ADEA is meant to, that's why there's that requirement in place, is to give the employee more information before they sign away their rights. And here we've got a link to the release and guidance about this. So this is, again, if you want a refresher before you're doing a release, this is a good way to look for it. But all the things that you need to give are pretty much on the slide. You've got to tell them information about the group layoff package if you've got one, eligibility factors for it, time limits, and then again, job titles and ages of all individuals who were eligible, who were selected for a layoff, and then, their ages, and then they've got to tell you people who weren't selected. So again, you can do a compare and contrast. So are there things that should be excluded from a severance agreement? Yes, there are. And employees can't waive their right, for example, to file a charge with the EEOC, DFEH, or another administrative agency that's basically involved in enforcing employee rights. So the EDD would be another one. The reason I think behind that is there's just California has decided there's a compelling public interest in making sure that employees enforce their own civil rights. And basically, when people don't go to the EEOC or DFEH, even when they think some huge injustice has occurred, just because they've signed a waiver, that's considered not good for public policy. So that cannot be limited. However, you can limit. At least there's been no direct cases saying that you can't do this. And what I do for my clients is I put something in there saying that the employee waives the right to get any financial compensation as a result of filing those charges. And to me, that separates out those who really believe they've had a serious wrongdoing to those employees who aren't sure but figure that might be a way of getting additional money that they may desperately need. And, it separates those that are highly motivated to file, from those that are really hoping to get money. And then, of course, if the employer has done nothing wrong, they don't have a lot to worry about. There will be an investigation, and then the investigation will likely find no liability, or no wrongdoing. And there's no financial consequences, at least on the part of paying the employee. The agreement also cannot limit the employee's right to testify, assist, or participate in an investigation conducted by one of those administrative agencies that we were talking about. And any provision in a waiver that attempts to waive these rights is invalid and unenforceable. And this is one of the reasons that you often see in contracts and severance agreements in particular, those provisions that say if any provision here is found unenforceable, the rest of it can still be enforced. So that is basically saying that, if, for example, you mistakenly put this in, then just that part would be invalidated, but you wouldn't have the whole contract be invalidated. And that is one reason to have a severability clause in your agreements. You also cannot include workers' compensation claims. Those have to be generally handled by a specialist, a workers' comp attorney, and that person is a specialist and usually knowing the Workers' Compensation Appeals Board, and the Workers' Compensation Appeals Board has to sign off on it. So generally you're not going to release a workers' compensation claim. You also cannot release, finally, claims for wages that are undisputedly owed. So for example, if somebody says that they are non-exempt and you've been classifying them as exempt, and there's really a good faith dispute about it, that is something that could be released. But you cannot, for example, not pay an employee. Say you're a startup that had liquidity issues and you just haven't paid your employees for several weeks or months or maybe, years. You cannot then have a release that says that you're going to pay them, $10,000 and we're all good. The release can certainly say that, and you can pay them the money, but they could easily go to the DFEH later, and the DFEH could say that's invalid. And you're probably not going to have a lot of ground to stand on. So you can't have people sign away their rights to wages. And again, this just kind of highlights the way that these wage and hour claims tend to be really strict liability offenses that, are really, they stand on their own and they have special rules around them. So what's the timing for lawsuits? Well, in California, employees generally have a year from the date the discriminatory act happened. So, for example, if the allegation is wrongful termination, that's pretty obvious. You're going to have a year from the date of the termination to file with FEHA, for example, to file with the DFEH, and to allege a violation of FEHA. And for the EEOC to make a federal claim, that's going to be 300 days. So it's slightly less time. It's about 2 months less time. But the tricky thing here for the employee, and a good thing for an employer to understand, is that if you're not dealing with a wrongful termination, say you're dealing with a sexual harassment claim, the claim is going to only be a year from the last act. So if there was sexual harassment alleged, but that happened 2 years ago, and then the employee is terminated, in year 2, that allegation is going to be time barred. They cannot bring a claim. So you want to look at when the acts occurred and make sure that if they were part of an ongoing practice, that at least the last act occurred within the last year. Once the administrative agency issues a right to sue letter, and that's generally done pretty quickly, a few weeks, and you have to generally request that. You let them know, do you want an investigation or do you want a right to sue? A right to sue is basically just saying, I'm ticking off this box, I passed this administrative hurdle, I want you to allow me to bring a private lawsuit now. And then the employee has a year from the date on the right to sue letter to file a lawsuit. That is to, file a complaint in Superior Court. So a couple of last tips about termination before we start to, get into winding down this presentation is, really, I am a big advocate for telling your employee why you're terminating her. It should hopefully, if you've done the things, if you've let the employee know that there are problems with her performance and you've been really specific and you've been telling her all along and you've put her on a PIP, this is not going to be a surprise. You're not going to have to articulate all the reasons. But if it is a surprise, all the more reason that you want to tell the employee why you're terminating her. Because, and I have to say, I want to acknowledge here that I hear a lot of employment lawyers not giving this advice. But I really think that employees make up in their mind kind of the worst case scenario in terms of why they're being terminated, unless they're told why. And when you don't tell them why, they think that's really fishy and they make up a reason. So I think it's really important for them to understand, even if it feels harsh at the time, for them to understand that, there are real issues with your performance, and particularly to point, if you haven't been doing progressive discipline, to point to past instances where you did give them warnings about their those issues, even if you didn't do it in kind of a formal process. I do recommend a severance and release if you have a potentially litigious plaintiff, and I think it's never a bad idea to do it in all cases, just to know that you have peace of mind. You have a release and the employee is not going to bring something against you, even if it's a meritless claim. this next recommendation gets into a little bit my privacy expertise, but I do think one really important thing is to have a policy in your handbook or have a separate sign-off somewhere where the employee says that anything they do with company hardware or software or on company time is the property of the employer. So if the employee leaves and you need to get access to their files, but you go to the hard drive on their computer and it's not there, chances are some key files were emailed to people, and you want to be really clear with the employee that anything that they do on company time or with on the company server, with company email account, or even on their private account, but done, on company time or with company hardware, is the property of the employer. You want to cast a wide net, which basically tells them that they don't have expectation of privacy in those things, so that if you need those things either for just expediency, practical reasons, or you need it for a lawsuit, then you have easy access to it. Finally, be aware that even after termination, an employee is entitled to her personnel files or his personnel files. And this is a good rule of thumb to think about, is putting in the personnel file anything you'd be comfortable with a jury seeing. So of course you're going to have in there, just standard paperwork that they sign, things like that. But also that's a good place to put, discipline issue notices and emails, even maybe about the employee's performance, but exercising some discretion as you go. This is a really important point. As you go, exercising some discretion about what you put in there, maybe not putting everything in there if you think some of it is not things that you necessarily would want to turn over. But you can't do that later on when you fear a lawsuit or you're in the middle of a lawsuit. You want to do it again as you go, and you want to have kind of the same rule of thumb for all employee files. But again, just keeping in mind that what you put in there can be turned over to the employee, and it's not a bad thing to remind the employee of what their disciplinary issues were. But anything that goes in there that could be problematic for the employer, you really want to exercise caution around. And now I'm going to turn it over to Beth to do the final wrap-up.
So on this slide, we've just listed some resources that we think are really helpful, and we've also included links. So if you have the slides, you can directly go right to the website. We have information on COBRA, more information about at-will employment and wrongful termination. And then, as I mentioned earlier, on our website, we do have a lot of termination resources, including links to some of the forums that I talked about. And then finally, we've listed our contact information here. We wanted everybody to have our direct phone number and email addresses so that you could contact us if there are questions that you have that are more specific to your situation, or if we didn't address something in today's talk. Also, as a reminder, if you are an attorney seeking CLE credit, go ahead and email your bar number to Lauren at that email address listed there, and then Lauren will send you back your certificate as soon as we have approval from the bar.
And a couple more housekeeping items. Those who joined late, I just want to remind or say again that there will be a recording of the presentation, and probably what we're going to do is, because we started recording a little late, is record the first part on our own, and we'll synthesize those two. So it may take us an extra day or something to get it up there, but we should have a full recording up on the website. And finally, and I saw another question come through, and we'll answer that. And please, this is a great time to jump in because we do have some time. I anticipate we'll still probably end a little early, but this is a great time to jump in and send your questions to us via chat. Again, the PowerPoint should have been sent to you, and it will also be put up on the website, so you can send people to it if you'd like. And you have Lauren's email address here to send your CLE information to, your bar number. Again, give us a little bit of time because we don't have approval yet. And we'll shortly be sending you a survey, and you fill that out. You'll get a link very quickly to the recording and the PowerPoint. So there was a question about how long do employers need to keep employee files after termination. You know, I'm asked this question a lot, and it's 3 years. Beth's telling me it's 3 years. I didn't actually realize there was a legally required period of time.
Well,
Is that just in California?
I've seen, what I've read about it is that people say that if you maintain them for 3 years, then you should be completely safe.
Good.
Like, that's a conservative amount of time.
Yeah.
But I'm all about doing exactly what you should be doing to make sure that you're not going to get into any trouble.
Yeah.
With that. So I would say 3 years.
And I would say on the flip side of that, when those files start to get really stale, you shouldn't keep them around. I mean, there's privacy issues with that. And it does happen. I mean, I do work for one employer where, we get subpoenaed all the time for things and we just don't have them anymore. Now we do tend to keep things for a long time. So, we go out and we look at the archives, but there's nothing wrong. Like, once that information gets really stale, you should be shredding it. That's a privacy protection for the employee as well, because you have a lot of personal information in that file on the employee. And I'm just going to give it another second or so. And Beth's showing me something that says employers must maintain a copy of each employee's personnel records for at least 3 years after the termination of employment. But this is a good point, actually, a very good point. But as wage and hour violations contain a 4-year statute of limitations, the employer should retain the employee's personnel records for at least 4 years after the employee leaves its employment. So actually, I'm going to amend that answer and say 4 years. Just given how prevalent wage and hour lawsuits are these days, I think that's a really good point. But after that statute has passed, you could get rid of those. Okay. So there's another question about, can you elaborate on what you recommend is appropriate to tell other staff about an employee termination, the poor performance, for example? Not even mentioning they were fired versus a voluntary quit. I think so. I think, other staff, I see. So I think it depends on who the person is. I mean, if it's someone if there's a really compelling reason to tell them that, like, for example, if you're going to hire someone to fulfill that person's role, and the person that you're thinking about telling is going to be involved in that hiring decision, or be supervising that person, I think it's fine to say, look, we actually had to let this last person go, and here's why. But people who don't have a reason to know, I think it's much better to just say, we've decided to part ways, or so-and-so decided that it was time, so-and-so resigned, or, I think this is one time when it's fine to not be perfectly honest, that you have an agreement with the employee about what they're comfortable with, and it's something that you're comfortable with as well. And again, if you need to, if you're scrupulous about, well, I don't want to tell a lie, then you just say, we agreed that, at this time, we weren't a good mutual fit, or something like that. Again, make sure the employee is okay with it. And then, sticking to that agreement, I think, is a really good idea, just because the less people that know, the less likely you are to get into a situation where rumors start to get spread, and, the situation quickly gets out of hand with the number of people that know about it, and then it coming back to the employee. Finally, there's another question about, are there any special cautions when, by the way, Beth, did you want to add anything about that?
No,
okay.
I agree with everything you said.
Are there any special cautions when terminating someone who has an open workers' comp case? Yes, there definitely are. And I'm not a workers' comp attorney, but I'll tell you my experience kind of co-advising on cases when there is a workers' comp claim, where I worked with a workers' comp attorney and I've handled the employment. So there is a cause of action. It's a 132A labor code violation that says that you terminate someone as retaliation for bringing a workers' compensation claim. The idea being that workers' compensation claims cost money to the employer. The insurance is going to going to go up. If nothing else, maybe there's a deductible. And so the employer retaliates by terminating. So you want to exercise a lot of caution about terminating somebody when they've got an open workers' compensation case. I'm not saying you never do it, but I do think you need to have pretty compelling reason to do it, because you need to be aware that those cases happen. And I would say that that would be a great time to consult a workers' compensation attorney. So for example, they can tell you the climate at the time, how likely are courts to find a retaliatory termination. I think right now word on the street is that it's fairly easy to do that they are prone to be quite pro-employee, and they'll find that almost any termination while a workers' compensation claim is pending is retaliatory. But I've heard different workers' compensation attorneys differ. So finding a workers' compensation attorney that you trust and talking to them about it, I think, is a really valuable thing. And I think most good employment attorneys are not going to, unless they happen to have a specialty in workers' compensation, it's a very specialized field, and most of them are going to want the input of a workers' compensation attorney. And I'm just going to give it one more minute and see if we have any more questions. Okay, so seeing no further questions, we are going to bid you adieu. And again, feel free to reach out to either myself, Beth, or to Lauren. Lauren is a paralegal as well. And thank you so much for joining us today. And we will have the materials out shortly. And have a great day.